Let's look at how what the English believed about our rights influenced America and her founding. It's only natural that what the Englishmen believed and expounded upon did influence America, because so many of the founders had ties back to England. They had come from England, they had family members in England, they corresponded with people in England. There was a lot of influence back and forth. So in order to understand how America was founded, it's important to understand what was going on in England at that time, and then look to see what people took from the English thought, how that was incorporated into American laws and ideas. America does have various bills of rights in their state constitutions. There's also a document called the Pennsylvania Declaration of Rights. It shows some of the influence of what the English had said. It says, all power is originally inherent in and consequently derived from the people. Therefore, all officers of the government, whether legislative or executive, are their trustees and servants, and at all times accountable to them. Well, that's similar to John Locke, saying that the government is accountable to the people. The Pennsylvania Declaration of Rights also says that the people have a right to freedom of speech, of writing, and publishing their sentiments. Therefore, the freedom of the press ought not to be restrained. That showed agreement with Cato that as a natural right, our free expression was limited by the rights of others, including the right to reputation. We have the right, but we have to keep in mind that other people have rights as well. That's an example of how English thought was influencing American government as it was being formed. When the new American Federal Constitution was proposed, one of the biggest objections to it was it did not have a Bill of Rights included, and a lot of people wanted those specific protections for specific rights. Virginia recommended that freedom of expression be addressed, that the people have a right to freedom of speech and of writing and publishing their sentiments, that the freedom of the press is one of the greatest bulwarks of liberty and ought not to be violated. Sooner or later, the American federal government did form a Bill of Rights. James Madison was instrumental in that. In June 1789, he introduced his proposal for the Bill of Rights. The bill was to limit and qualify the powers of government by accepting out of the grant of power those cases in which the government ought not to act, or to act only in a particular mode. They were really trying to define what the government could do and what it couldn't, and what all the people could do and what they shouldn't do. There were two categories of rights that would be protected. One was called natural rights, those rights which are retained when powers are given up and are exercised by the legislature. So we have rights, but sometimes we choose to give them up and let the government handle things. There's also positive rights, which were considered essential to secure our liberty, such as trial by jury. Americans take that for granted, but that has not always been the case, that we can be tried in a court of law and heard out by our peers, trial by jury, to help ensure that we get a fair hearing and fair punishment. Conservatives regarded freedom of expression as an ordinary liberty that was subject to regulation for public good, whereas libertarians viewed it as an inalienable right limited only by the rights of others. So within America, there's contention back and forth. Are they alienable rights? Are they inalienable? How much protection should they have? How far can we go? Blackstone was not the inspiration for the Bill of Rights, because he viewed our freedom of expression as part of natural liberty that is alienable and subject to legislation. The purpose of the Bill of Rights was to specify freedoms that Americans saw as inalienable and to preserve them from government control. They wanted to be very, very clear that government, you may not infringe on these rights. These are absolutely to be protected. The Republicans denied the federal power of press, but did not regard freedom of speech and press as absolute. The Republicans also said that freedom of expression was limited by the rights of other people, something we've heard several times now. And the protection of rights belonged to the states, not to the federal government. Now that's a different idea. That instead of the big federal government protecting our rights, the individual states should, that was the state's responsibility. In the 1700s, Americans believed that freedom of thought, belief, and expression were among their natural rights. That it was part of citizenship, allowing people to express their views on public affairs and guard their liberties against the government encroachment. That natural rights, freedom of speech, and press were rights but limited by the rights of others. So this video was a synthesis of how Americans were viewing freedom of speech and expression in the 1700s as they were struggling to form a new country, to form a new government, the struggles between federal government, state government, what rights, who's going to protect them, how far do we go. In the next video, we will look at what Stephen Heyman, the author of this article, refers to as the transformation of free speech theory. How has free speech theory evolved over time? What did it look like before? How has it changed? How are people interpreting it differently?